Good evening, ladies and gentlemen, my lords. Thank you all for coming. I'm Jonathan Morgan, the Deputy Chair of the Faculty of Law. It's disappointing that an occasion such as this, valedictory lecture of the Regius Professor, should not be held in the faculty building owing to the strikes. On the other hand, there is something fitting about having it here at Corpus Christi College. So David was a fellow of Corpus from 2000 when he assumed the Regius chair until 2013 when he became president of Clare Hall. Moreover, David was an undergraduate and then a PhD student at Corpus in the 1970s. And valedictory lecture has a slightly sad note of farewell, but I can reassure everyone that David will remain among us writing his books and is still teaching Corpus first years Roman law, as he has done for the last 23 years, and long may it continue. So as a fellow of Corpus myself, you're all very welcome to the college. Particularly, I'd like to welcome and introduce Mr Justice Foxton. Sir David Foxton read law and the BCL at Magdalen College, Oxford, in the 1980s, where his tutor was one David Ibbetson, during what those of us here will think of as the Babylonian captivity period in the other place. David Foxton was notably scholarly commercial silk. In his spare time, he did a PhD and wrote a biography of Lord Justice Scrutton. And he is now an extremely learned judge. And anyone here who was in my contract lectures this week will have heard about Mr Justice Foxton's views of the Misrepresentation Act, for example. So, David, thank you so much for coming, and Mr Justice Foxton will now introduce David Ibbetson. Thank you.
I must have first met David Ibbetson in December 1982, when interviewed for a place to read law at Magdalen College, Oxford. As is so often the way with traumatic events, I have absolutely no memory of the occasion, but later learned that David thought there might be just enough about me to persuade John Feltham and Roger Smith that I was worthy of the last available place. I got to know David properly when I arrived the following October. It is no exaggeration to say that from an intellectual and professional perspective, that was the most significant encounter of my life, opening up a range of possibilities and interests that 40 years on remains highly relevant in my life. David's magisterial study of the history of the law of obligations has very few omissions, but I don't think he refers to the fact that there are some debts whose scale is simply so great that it is not possible properly to capture their measure. Now, on an occasion such as this, there is understandably a focus on David's hugely impressive body of research and publications. There were clear signs of that in 1980s Oxford. In particular, David's article on Slade's case had come out, which I think was an important milestone towards the history of the law of obligations. But it was another aspect of David's enormous contribution to law as an academic discipline, which was very much to the fore. David's extraordinary abilities as a teacher. I was fortunate that David taught me 5 subjects, all of them compulsory. There was Roman law and criminal law for moderations, taught jurisprudence and legal history for finals. There are some of you unable to believe that even in the 1980s, legal history was a compulsory subject. The answer is it was at Magdalen in David's time. Had I the appetite for it, I could have studied family law with David as well. His renowned legal eclecticism was already well established. An Ibbetson tutorial is a hugely enervating and enlightening experience. When he managed to coach a rare good point from us, he would come to the forefront of the armchair eyes wide in excitement, and try and encourage us to run with the point to see where it might lead. More mixed offerings led to bouts of armchair gymnastics as he moved around different parts of his armchair and separated the wheat from the chaff. Bad points would generate prolonged bursts of what I can only describe as facial gurning, in the course of which images that would have been entirely at home with the gargoyles of Longwall Quad would put in an appearance. And on those occasions, alas many, when we spoke complete rubbish with that utter certainty of youth, we would very often attract the ultimate Ibbetson insult. It was a four-letter word with an S, an H, a vowel, and a T in it. I had wondered whether this was too august an occasion to voice it, but I suspect there can be few here today that David has not told them they are talking tosh at some point or other. Now, the range of David's teaching interests have, if anything, been exceeded by his research. The breadth of his legal scholarship, in terms of its subject matter, its chronology, and its geography, is really quite remarkable. And there are three particular themes of David's work as a legal scholar, to which I continue to aspire, and which continue to inspire and motivate me in my second career. First, there is his passionate interest in all areas of law, not simply for the joys of variety, but because each has something to tell us about many of the others. Alas, there has been a pressure to specialise both in legal practice, and I think sub rosa at least, also in the judiciary. But David's legal polymathy should inspire us all to push against the boundaries of our so-called areas of expertise and explore pastures new. Second, and of course this will come as no surprise, an appreciation of the extent to which an understanding of law as it is and as it could be benefits from an understanding of its historical development, how and why legal principles came to be formulated in a particular way. And finally, how much even the most passionate devotee of the common law can learn from the study of other legal systems, be they ancient or modern. I'm sure we will see each of those three themes in the course of David's valedictory lecture this evening, entitled Roman Law, Comparative Law, Legal History, which is now my great privilege and pleasure to ask David to deliver.
Thank you very much for that, David. I do remember your entrance interview. I remember it very well. We were both very badly hungover for the experience. And there was a fellow feeling between us that we each knew what the other was suffering from. But anyway, that's water under the bridge. Inaugural lectures can be intimidating. My distant predecessor, the first Regius Professor, Thomas Smith, had every reason to be concerned when he gave his pair of inaugural lectures in 1542. His only qualification as a scholar of Roman law was that he was the second best scholar of Greek in Cambridge. And, he said, he had bought a copy of Justinian's Digest and dipped into it in his leisure hours. History does not record whether that was enough to convince the scholars in his audience that he was the right person to hold what was then a well-endowed office. But an inaugural lecture does have something approaching a template. A few deprecative words of praise for one's predecessors, whether genuinely meant or not, are followed by the new professor laying out his or her stall, saying how they see their subject and what is important within it. For Thomas Smith, this meant stressing the newly fashionable humanist learning that he had picked up in France and Italy, departing from the earlier exegetical Mos Italicus. History does not record whether that was what he actually did. The marginal notes he made on his copy of Justinian's Digest perhaps suggested that he stuck to the old exegesis. But a valedictory lecture has no such template. It is by nature backward-looking. If an inaugural is a credo, a valedictory risks being an apologia pro vita sua, answering the normally unspoken question, what's he been doing all these years? Has he learnt anything from it? But I remember as a student being inspired by the valedictory lecture of our late friend and colleague Kurt Lipstein. In its published form, its title was Acta et Agenda, loosely translatable as What I Have Done and What Remains to Be Done. It was not so much the content of Kurt's lecture that had an effect on me, so much as the title. Even on retirement, at what then seemed to be a great old age, a scholar could still look forward. 30 years later, Kurt was still doing so. So this lecture is what I have done, what I have learnt, and what remains to be done. But I shall begin with some personal reflections. Stepping down from the chair, I look back at those to whom I owe debts of gratitude. To my family, who kept me more or less sane and made sure I didn't forget that there was life outside the academy. To my colleagues, who have forever stimulated me into thinking about law, even when I have disagreed with them profoundly. And to my students, undergraduates who raised questions I could not answer at first sight, and graduate students who answered questions I had never thought to ask. And a bit on behalf of all of us, thanks to the organisers of this event, whose task was made a good deal harder by the need for last-minute reorganisation. I never gave an inaugural lecture, but if I had done, I would have said that I would carry on working on the history of English private law, and though with an eye to its relationship with Roman law, and more generally working on comparative legal history. I have spent the last 20 or so years doing just that, though the Roman law I have been looking at has broadened into the whole Romanized tradition on the European continent and elsewhere. Sometimes this has involved metaphorically looking under stones to see if there is anything there, though I'm afraid more commonly it has been the result of metaphorically picking up a shiny stone because it looked lovely and discovering by pure chance something interesting underneath it. An important figure in my work has been the 18th century polymath and lawyer Sir William Jones. He is probably better known today as the philologist who identified the genetic relationship between Sanskrit, Greek and Latin, triggering the subject of the study of Indo-European linguistics. But many lawyers will have heard of his little essay on the law of bailments, first published in 1781, even if few have actually read it. The title promises more than the book delivers. It does not deal with all the legal problems that the bailment relationship gives rise to, and they are many, but only one of those problems: the standard of care owed by the bailee, the borrower, to the bailor, the lender. How much care he ought to take of the property while it is in his possession. But this was, in truth, a big enough topic in itself. The English case law on the subject before 1700 was extraordinarily confused. And the situation had only been made worse by attempts to impose order on it by treatise writers from Bracton and his colleagues in the mid-13th century to Christopher St. Germain in the early 16th. but the subject had been reduced to something like order in 1703, in the great case of Coggs and Barnard. Chief Justice Holt had there reinterpreted the earlier case law and aligned it with what he repeatedly called the law, that is, Roman law. Holt's reasoning was utterly opaque and, on analysis, totally incoherent. But it did produce a few general principles, a great deal easier to apply than the confused mishmash of the previous law. It was neither the first nor the last case where a welcome result was reached by transparently bad reasoning and never subsequently questioned. When Jones came to write his little book, the rules defined in Coggs and Barnard had been in place for 3/4 of a century, and he was able to say that his work was merely a commentary on the earlier decision. Maybe, but Jones went a good deal further than that. He did not merely reproduce the law of Justinian's institutes, the law, as Holt had described it, but ventured into a critique of the more detailed texts in the digest, analysing them, and even from time to time arguing for an emendation of a received text. Unlike Holt, he also cited more modern scholars' writings on the Roman texts, and even if some of his references were blind citations picked up from other writers, he clearly at least looked at some of the books he had referred to. Perhaps most significantly, with hindsight, he made use of the works of Robert-Joseph Potier, which he had introduced into England and which were to be the main source of the principles of modern English contract law. Sometimes, I'm afraid, and this will shock you, he plagiarized them shamelessly. It was more difficult to shoehorn the English case law into the framework which he had derived from the Roman law, and it has to be said that he was as cavalier in his use of these as Holt had been, sometimes reading facts into decisions to make them say what he wanted them to say, sometimes blatantly reinterpreting them. Did he need to do this? Could he not simply have started with Coggs and Barnard and ignored the pre-1700 decisions by saying that they had already been explained? The answer, I think, lies in an important assumption about the nature of the common law. Like many lawyers of the 18th century, he was in thrall to a theory of natural law, making this explicit in his essay. If law be a science, and actually deserves so sublime a name, it must be founded on principle, and claim an exalted rank in the empire of reason. But if it be merely an unconnected series of decrees and ordinances, its use may remain, though its dignity be lessened, and he will become the greatest lawyer who has the strongest habitual or artificial memory. The whole of Jones's essay is structured around the methodological assumption that law is indeed a science. Following the German, Johann Gottlieb Heineccius, whose work he would undoubtedly have become familiar with while studying at Oxford, he begins with an analytical part, delineating the subject from first principles of natural reason. Then comes the empirical part, showing how the rules of developed systems conformed to this model. Finally, the brief synthetic part, detailing the fundamental rules. Roman law was undoubtedly a developed system. The common law was too, and in Jones's view, had been a developed system from at least the 13th century. It followed their rules, the rules of Roman law, the rules of English law, must conform with his starting point of natural law, even the rules found in the yearbooks of the 14th century. And why? Why limit it to English law and Roman law? He also refers from time to time to Gothic, Greek, Hebrew, Turkish, Visigothic, Bavarian, Frankish, Welsh and Hindu law, though only, of course, where they were consistent with his natural law starting points. Although the natural law writers of the 17th and 18th centuries claimed to be building up their ideal systems from unquestionably true starting points, their reasoning from these starting points was frequently rather more questionable. For all of them, I think, the ideal legal system they had in their minds was that of 6th century Rome, the law of Justinian's Corpus Juris, and especially the law of the classical Roman jurists. It was unsurprising, therefore, that Roman law turned out to be more or less consistent with the principles of natural law. English law was not such an obvious fit. Even a shoehorn might not have been enough, and a straitjacket was needed. But let me return to Jones himself. The law of bailments might have been the very worst topic to have chosen as the first of a series of projected monographs, no more published, as booksellers' catalogues might describe it today. From a Roman perspective, bailments were contracts, the so-called real contracts, and the standards of care appropriate to each contract were the default rules in the absence of any agreement to the contrary. But by the 18th century, it was not so easy for natural lawyers. It was coming to be treated as axiomatic that contractual liability stemmed from the meeting of the minds of the parties. And it was not enough to say in gratuitous deposit for safekeeping, for example, the bailee was only liable for gross negligence or deliberate wrongdoing. It was necessary to say why this was so, if there had been no express agreement between the parties. Like a good common lawyer of today, Jones said we could infer or imply that this was their tacit agreement. But every good common lawyer of today knows in his or her heart, whenever we say that something is inferred or implied, we may well be sheltering behind a weasel word to allow us to reach a desired conclusion. Jones's inference or implication was always just that, with little reason to suppose it was anything more. Worse, cases of bailment in English law were situated rather uncomfortably between contract and tort. In form, they were tortious. From the 1360s, actions of trespass on the case. But from 1500, as I'll speak about in a few minutes, the action for breach of contract was also trespass on the case. And it was in practice impossible to say whether the action was tortious or contractual. Either view raised potential difficulties in practice because of technical rules of procedure. Jones, like Chief Justice Holt before him, categorised them as contractual, though unlike Holt, he simply assumed it. 20 or 30 years later, they were clearly being seen as tortious. Jones was able to carry across the Roman contractual rules into England without too much extra trouble, but there was the potential for friction. Why does this matter? Well, it was already coming to be said, and again derived from natural law, that you are under duty to take reasonable care not to injure your neighbour. But the core Roman contract rule, central to Jones, was slightly different. The duty to take the care that would be taken by a bonus paterfamilias, or as we would say in the 19th or 20th century, the care that would be taken by a reasonable man. From the 1830s, not only were bailment cases tortious, but this reasonable man standard of care had come to apply generally in the law of tort. Reasonable care and the care of a reasonable man were almost equivalent, but only almost. If the duty was to take reasonable care, it was for the jury to use its own standards of reasonableness. If the care of a reasonable man, the standard was external to them. Juries might not think that it was reasonable that railways killed so many people. But if they're asked what a reasonable railway company would do, they might feel constrained to accept the normal practice, unless, of course, they simply ignored the judge's direction, which is almost certainly what they did. We are stuck with this terminology today, though the law has been able to adjust its reasonable person standard to achieve desired results. A 15-year-old has to act as a reasonable 15-year-old. By contrast, a learner driver has to act as a reasonable qualified driver. And if I could steal the thunder of my successor, speaking of her legal system, a poodle has to act as a reasonable poodle. We are back in the pre-Jones world of asking what constituted reasonable care in the circumstances. It is not difficult to see the attraction of natural law, and behind it Roman law, to Jones. It was a well-structured system, scientific in the sense that Jones had used the word, and it was self-consciously underpinned by attractive ethical principles. Had he lived to 1808, he would have had some sympathy with the deputy in the Louisiana Assembly, who successfully argued that Louisiana should have a code based on the mode of the French Code Civil, rather than wading into what he described as the horrible chaos of the common law, el horrible chaos del common law. But there were negative sides to natural law too. Fundamentally, as I think Jones recognised and could not resolve, there was a tension between the well-structured system founded upon abstract propositions, but throwing up many points of potential disagreement and the need for authority to resolve those disagreements, at the risk of destroying the self-consistency of the system. My own belief is that it was this tension that brought the classical period of Roman law to an end early in the 3rd century. Too many points on which very able jurists could disagree, and allowed the system of imperial authority to replace it. One authoritative answer to a legal question was far better than 2 or 3 intellectually convincing but inconsistent answers. A second problem was that it was too easy to believe that the propositions of natural law were fundamentally true, that all legal systems were at heart the same. Hence, having become a judge in India in 1783 and taken up the subject of the study of Sanskrit, he translated the important Hindu work of perhaps the 2nd or 3rd century AD, the Manavadharma Sastra, publishing it as the Institutes of Indian Law, or the Ordinances of Menu, in 1794. The title makes it clear that for Jones this was equivalent of the Institutes of Justinian. It was the basic manual of Hindu law. But it was nothing of the sort. And though it did contain norms we would certainly describe as law, it is better to think of it as a guide to proper conduct. He also set in train the creation of an ambitious digest of Hindu law, consisting of extracts from texts sewn together in the manner of Justinian's digest and reflecting very closely some of the detail. It should contain, he said, and I quote, a more ample repertory of the 12 different contracts to which Ulpian has given specific names, and on all the others, which though not specifically named, are reducible to 4 general heads. Hindu law surely must be structured in the same way as Roman law, just as the English law of bailments must mimic the Roman law of real contracts. The same assumption was made explicit by judges in India in the generations after Jones's death. It was a commonplace observation in the Anglo-Indian courts and in the British Parliament that so far as contract was concerned, Hindu law was the same as English law. It was a classic example of what has been described as a process of converting Indian forms of knowledge into European objects. I suspect that this was inevitable, given the 18th century belief in the objective universal validity of natural law principles, an assumption explicit in Blackstone's commentaries. I quote, "The law of nature, being coeval with mankind and dictated by God himself, is of course superior in obligation to any other. It is binding over all the globe, in all countries, and at all times. No human laws are of any validity if contrary to this." Such a view of natural law as the basis of common law fell out of fashion in the 19th century as the positivism of John Austin took over. But we may be moving along the same lines today, with private law theorists identifying true principles, and more generally as we impose liberal Western sets of values onto different cultures through the fetishization of human rights. Should we see in Jones a reflection of a tension within ourselves? He was a thoroughgoing anti-colonialist, a strong supporter of American independence, and a passionate believer in allowing Indians to be governed by their own customary laws. But at the same time, he was blinkered into granting a universal validity to the natural law, which was in truth a projection of Roman law. Thus far on the actor side of the line with Jones. But there is something on the agenda side too, a fascinating loose end I have not tied up. That is Jones's share in the making of the Second Amendment of the United States Constitution, the right to bear arms. Jones had been caught up in the Gordon riots in 1780. The civic authorities had lost control of the city, and Jones played his part in the Inns of Court militia, in time regaining control of the streets. Reflecting on this, he published a pamphlet on the proper mode of the suppression of riots, arguing that all citizens should arm themselves in some way and trade regularly, ready to be called on to support the civil power. A duty to bear arms. Slightly later, the result of a conversation with Benjamin Franklin, among others, he penned his Dialogue Between a Scholar and a Peasant, in which he reduced his libertarian political philosophy to principles so simple that they could be understood by anyone. One of those principles was the right of individuals to arm themselves, to protect themselves against the abuse of governmental power. The dialogue leading to the peasant saying that he will certainly keep a flintlock in his farmhouse for the purpose. A right to bear arms. Franklin, we know, approved of the pamphlet, which incidentally gave rise to what will be one of the more absurd episodes in English legal history, as Jones was very hurriedly indeed shipped off to take up his judgeship in India at the same time as his brother-in-law was being prosecuted for sedition for disseminating Jones's pamphlet in Welsh. We could see his developed views on the bearing of arms in an address to the Grand Jury of Calcutta some years later, in which he described the rights most fundamental to the protection of the individual: the right to play a part in the election of the legislature, the right to trial by jury, and the right and duty to arm oneself. I shall leave it to others to burrow deeper into this rabbit hole. Let me return to private law. One topic I have several times returned to, as a dog returns to its vomit, you might privately think, by the time I have finished, is that area of law which we probably know as unjust enrichment or restitution, though in continental Europe it is generally known as unjustified enrichment. This area of law, if it is one, has provided useful utility over the last 8 or 9 centuries as a way of providing remedies in a variety of situations. Its anchor point in Roman law was a Stoic philosophical principle that it was fair that no one should be enriched to the detriment of another. Though a second version of the text says that no one should be enriched to the detriment and wrong of another. But this was a very general statement, with no more bite that the one should give every man his due. The legal core of the area of law was the remedy known as the condictio, applicable principally either when there was a contract to pay a fixed sum of money or where there had been a transfer which ought to be reversed, typically where money had been paid in the mistaken belief that it was owed, or where there had been a transfer made without a legally recognised cause. Finally, there were the quasi-contractual obligations, where a person was liable as if there had been a contract, but when there had not been. I shall spare you all the ins and outs of the last 9 centuries or so. They are legion. Medieval scholars of Roman law stuck largely with the Roman texts, though from the late 13th century, starting in France, it appears, there was something of a dalliance with the idea that a condictio should lie whenever it was equitable that it should. The idea found its home in Holland, Frisia, and Germany in the 17th and early 18th century. I think for the first time linking the availability of the remedy to the general principle that none should be enriched at the expense of another. The English common law was having none of this. Legal practice just squeezed difficult situations into existing remedies without any attempt to theorise. The treatise known as Bracton from the mid-13th century reproduces the Roman text on the so-called quasi-contracts without comment. It bears no relation whatsoever to what was happening in courts. Only in the 17th and early 18th centuries do we find recognisably non-contractual remedies, for example in the form of indebitatus assumpsit for money hadn't received, or non-contractual actions of quantum meruit. Text writers kept their heads in the sand and tended to speak of them as based on implied contracts. After all, the form of action was assumpsit, and assumpsit was normally contractual. It was only with Lord Mansfield that was any serious attempt to generalise. Borrowing either from the Frisian Ulrich Huber or the German Heineccius, the same Heineccius as Sir William Jones had borrowed from, he articulated a general principle that money or other property could be claimed whenever it was just and equitable that it should be. But this was far too broad, and within a few years he backtracked. leaving equity with its overtones then of the Court of Chancery behind. England drifted back into its implied contract analysis. With apologies to non-lawyers present, and I think to lawyers too, I cannot resist quoting Frederick Pollock's explanation of the law in the latter part of the 19th century. It does not follow that because there is no true contract, there may not be cases falling within this general description in which it is just and expedient that an obligation analogous to contract should be imposed upon the person receiving the benefit. In fact, there are such cases. And as the forms of our law do not recognise quasi-contracts in any distinct manner, these cases are dealt with by the fiction of an implied previous request, which often has to be supplemented, as in the action for money had and received, by an equally fictitious promise. The promise, actual or fictitious, then relates back to the fictitious request, so that the transaction, which is the real foundation of the matter, is treated as forming the consideration in a fictitious contract of the regular type. So much for English law being a science. Meanwhile, in Germany, the great Friedrich von Savigny had explained the law in terms of the reversal of transfers made without a legally recognised cause, grundlose Bereicherung, unjustified enrichment. But when this was translated into French, it came out as enrichissement injuste, unjust enrichment. The French was picked up by the American legal historian James Barr Ames in 1888 as the explanation of the 17th century English cases, and in the common law world, the terminology of unjust enrichment eventually stuck, conveniently sucking in some of the chancery ideas with their rooting in equity. Now we find German lawyers questioning the whole idea of unjustified enrichment, English lawyers questioning the whole idea of unjust enrichment. There is no better antidote to a belief in the timeless and fundamental rationality of the law than a good dose of legal history. Let me turn from the sheer confusion of the enrichment remedy, to the perhaps calmer waters of contract law. This was the starting point of my research career. My PhD thesis dug deep into manuscript law reports of the 16th century in an attempt to elucidate what appeared to be the foundations of the modern law of contract in the action of a sumpsit. The starting point was in the middle of the 14th century, in what we would think of as the law of torts. A person who had been injured by faulty medical treatment, for example, had come to be excluded from the core action of trespass, which had an allegation that there had been a forcible breach of the king's peace, and breach of the peace could not properly be alleged when the defendant had been acting with the consent of the victim. The same applied when property was damaged by a bailee. The solution was to allow the action to proceed without an allegation of a breach of the king's peace, but with a brief statement of the circumstances in which the alleged wrong had been committed. Since the problem in many of these cases, these actions on the case, was that the defendant had been acting with the consent of the victim, it became common to allege that he had assumed to do something and done it badly. There was a technical problem, perhaps a conceptual problem of pleading, where this form was used in cases of non-performance of an obligation. After a century of uncertainty, it was settled that it might be used in such circumstances, the contractual dimension being stressed by the addition of an allegation that the defendant had not merely assumed to act, but had also promised to do so, picking up the idea of the liability for promising from the ecclesiastical courts. The action became popular, since it avoided some procedural difficulties of the orthodox contractual action of debt, and by 1600 it had substantially eclipsed the older remedy. History is perhaps repeating itself today in the way in which some fringe cases of negligence, especially cases where there has been an omission rather than a positive act, or where the rules of the law of contract have come to be seen as excessively rigid, are being brought in by alleging that there has been an assumption of responsibility. One of the doctrines that crystallised in the 16th century was the doctrine of consideration. The rule that in the absence of a sealed document, an undertaking was legally enforceable only if something had been given or done in exchange. This may have made sense in the 16th century, when social relations were underpinned by the giving of gifts in the expectation of receiving a gift in return. The only difference, The only difference between a gift and a contract was that in a contract the counter performance had been agreed in advance, whereas in a gift it was for the receiver to choose how and when to reciprocate. This medieval approach was perhaps on the way out at the time. Lord Chancellor Francis Bacon found to his cost that a gift might easily be characterised as a bribe. And by the 18th century, it was being argued that the doctrine of consideration had passed its sell-by date. A new model of contract had come to the fore, based on the meeting of the minds of the parties. But consideration survived, the fossilised detritus of the earlier model of contract. We are perhaps still stuck with it today, though it's easily avoidable by putting the agreement in writing and including a few magic words. Fail to do that, and there is no enforceable contract, although the merciful courts have managed to put at their disposal a whole toolbox of devices to avoid that result. Assumption of responsibility, promissory estoppel, proprietary estoppel, the invention of a nominal consideration, commercial exceptions, and so on. If we get one lesson from legal history, it is that the common law is not terribly good at discarding rules and doctrines once they have got into the treatises, the textbooks. Perhaps my favourite example of this inertia is in the rules of privity of contract, the rule that only a party to a contract can enforce it. It looks to have come from Roman law, and in the very particular conceptual framework of Roman law, it made sense. In England, it was an inconvenience, and from about 1240, any competent lawyer drafting a contract to be put in writing could avoid it, unless an unborn child was involved. It remained as a snare to trap the unwary until 1999. There are, of course, bits in the jigsaw of the history of contract waiting to be filled in. One is the relationship between the emergent doctrine of consideration of the 16th century and the Roman or continental Europe idea of causa. There are hints that some English lawyers were aware of this Romanized rules, and some scholars have developed the idea that the English rules derived from the continental. But I have to say, I've seen no evidence of this. A more important addendum is the crystallization of the legal boundary between contracts which were made in a sealed document and those which were not. I have spent, and I hope not wasted, many hours, days and months beginning to make some sense of this by looking at the formalisation of the action of covenant around 1300. One of the most important factors shaping the whole history of the English law of obligations, right up to the present day. But covenant was the tip of an iceberg, and there's a great deal still to be done. I suspect that on thorough investigation, it will be revealed as a prime example of the spawning of a nationalised common law distinction out of a very different Roman law distinction in the course of the 13th and 14th centuries. But I will leave that investigation to others. As the holder of a chair in Roman law, I have, of course, spent some time on the law of the ancient world. Whether I have said anything worthwhile about the law of Rome, it will be for others to say. What I have written on the subject has been rather aimed at clearing away the brushwood and debris of several centuries of commentary in an attempt to elucidate what was actually happening to the law in the millennium between the 12 Tables and Justinian. I have been more concerned with the comparative legal history of the ancient world. I believe a straight line can be drawn from the Mesopotamian world at the end of the 3rd millennium BC through the Hittites of 2nd millennium Anatolia and the Greeks to Rome. The great significance of Roman law lay not so much in its rules as in its methods developed at the end of the Republic. In particular, the reliance on reasoning by analogy. I have suggested, perhaps eccentrically, that the relatively recent discovery and translation of the Hittite texts has caused us to underestimate the importance of this still rather obscure system. It looks to me to have been possibly the first legal culture to have generalized legal rules from actual decisions in real cases. A very important step in the development of the idea of law as we think of it today. Some of these early texts have an eerily modern ring to them. A Sumerian text of the first decades of the 2nd millennium BC deals with the problem of a landowner who neglects his land, with the result that thieves are able to break into his neighbour's property. I wonder if they discussed what the right answer was at as great a length as the House of Lords did in 1987. More recently, I've been heavily involved in a project which is nearing its end, a comparative investigation of ancient legal systems, Mesopotamia, Anatolia, Egypt, Greece and Rome. They have enough features in common for us to think of them as a single legal cultural unity. But the same cannot be said for India and China. Neither of those had a word which we could safely translate as law, but there are occasionally equivalent practices in very, very different systems. In early China, for example, there seem to have been special formalities for the sale of slaves and cattle, just as there were in early Rome. Across Eurasia, we see the parties to a formal contract mixing their blood or smearing it onto a document of some form, generally over the centuries transmuting the mixing of blood into the ritual sharing of wine. Independent development, evidence of age-old contacts through Central Asia along what would come to be known as the Silk Road, or practices which could be traced back for many, many millennia. Our project may be nearing completion, but we've only scratched the surface of questions of this type. Something else for the agenda. My time is coming to an end, at least in the sense that this lecture is reaching its close. But I should say something about legal education. I shall keep it brief, since with this audience I suspect I may be preaching to the converted. Why should we teach Roman law, comparative law, and legal history? Let me begin with Roman law. It is a fact that most of the world's legal systems deal with private law in a very Roman way. My own belief is that this is true also of common law systems because of the work of Sir William Jones and his ilk in the 18th century. This prevalence of thought, traceable back to Roman law, is not simply a consequence of colonial domination. Such an explanation would not account for the Japanese Code of 1898 or the first Chinese civil code drafted in 1911. Nor does it really explain the experience of the newly independent states in South America in the 19th century, rejecting the Spanish and Portuguese-based laws of the colonial powers and choosing them to replace them with a code based on a French or German model. We can say that a knowledge of Roman law helps us to understand the conceptual vocabulary of these systems. But it's more than that. If we ask why those responsible for the drafting of civil codes have repeatedly turned to a Romanized model, the answer has to be that it's a rather good model. It would not be going too far to say that Roman law was one of the crucial forces shaping modern civilization, and that it was the single most important force in the shaping of modern legal culture. What about comparative law? I have no pretensions to be a comparative lawyer myself, but I have learnt a lot from working with comparative lawyers. The value of studying the subject is emphatically not that pointed to by William Jones in 1777, that, I quote, "The laws of England shine with greater lustre when they are compared with those of other nations." If legal systems reach different results in some particular case, we can learn from asking why that might be. And if they reach the same result by different routes, we might well seek to ask which route is the more efficient. Finally, legal history. We can, no doubt, conceive of law as a static system. When consulted by a client, the lawyer is expected to say what the relevant law is. But it's also a dynamic system, and the good lawyer advising a client must be concerned with what the law is becoming. You cannot see what the law is becoming without knowing where it has come from. And in English law, which has developed without any radical break for nearly a millennium, the dynamic dimension may involve looking back for centuries. Perhaps more importantly, in a common law system, there is value in being able to identify rules and doctrines which made sense when they were introduced, but have been left behind, the detritus from past ages. Jeremy Bentham said that in order to reform the law, you had to know what it was. He might have added that you had to understand where it had come from. In the opening pages of his De Legibus, Cicero tells of being asked by his friend Atticus to turn himself to writing a history. Cicero replies that you can only really write a history when free of work and worry. That is to say, when you've retired. His is a good model for a professor of Roman law to follow. So I now turn to writing the legal history which I should have been writing for the last 3 decades. I'm sure I will carry on looking under metaphorical stones, but when I find something interesting there, I will pass it on to someone else and turn back to my book. At least one person in the room today will be pleased to hear it. Thank you.
Well, Professor Ibbetson, you described Sir William Jones as a polymath, and I think we've all learnt this evening what we knew already, which is you are very much his equal in that. I think I lost count thinking of David Foxton's point about how many papers David Ibbetson had taught him at Oxford. I think it was about the 7th paper that I gave up. I didn't hear any family law, but we did hear about human rights, which is a good excursus from you. It was a wonderful lecture, an intellectual feast full of wise aphorisms and delivered in your own inimitable Ibbetsonian style. We wish you all the very best for your non-retirement and look forward to the book when it is done. Thank you so much.